Good morning, Miss Edwards.
Good morning.
Before your evidence begins, may I advise you that the terms of reference of the inquiry exclude the prosecutorial decision and review. At the beginning of the Crown Office hearing, I set out my interpretation of how the inquiry should approach that exclusion. The inquiry will not examine the ultimate prosecutorial decision of the Lord Advocate and his reasoning, your prosecutorial decision and reasoning, and the recommendations and advice given by the Procurator Fiscal in reporting the case to you. In addition, the inquiry will not examine in detail which particular potential crimes you considered could be relevant. Subject to these exclusions, the inquiry will examine the post-incident management process and the investigation conducted by the Crown. As the vehicle for the Crown's investigation was a criminal precognition, that examination will include the work associated with the precognition. Would you now take the oath? I swear by Almighty God.
I swear by Almighty God.
That I will tell the truth.
That I will tell the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Miss Graham.
Good morning.
Good morning.
You are Ashley Edwards.
I am.
And you're a King's Counsel.
I am.
What age are you?
58.
And you, as I understand it, went into Crown Office in 2008, is that correct?
I did.
And you have remained there until you were laterally appointed as Assistant Principal Advocate Depute and now Principal Advocate Depute.
Deputy Principal in between that.
Oh, sorry. So, Deputy Principal Advocate Depute.
Deputy Principal, Crown Counsel.
Crown Counsel, thank you. And you have provided an inquiry statement. You've provided a statement at the request of the inquiry. They sent you a ruling request. And in response to that request, you prepared written answers to the questions that were asked by the inquiry team.
I did.
And let's just very quickly look at that. It's the request was SBPI 00439. I won't put that on the screen. That's just for the benefit of those behind me. But your response was SBPI 00445. You'll see that statement given on Wednesday, the 17th of January 2024. It's your name, Principal Crown Counsel. And if we look, it's 14 pages of a PDF. If we look at the final page, now this has been redacted. Your signature is not visible to those looking on the screen. But as I understand it, you did sign it in the hard copy.
I did.
And it was signed by you on the 18th of January 2024. And the final paragraph, number 69, says, I believe the facts stated in this witness statement are true. I understand that this statement may form part of the evidence before the inquiry and be published on the inquiry's website. And that was your understanding when you signed?
It was.
Thank you. Now, you were doing your best, as I understand it, when you completed this statement to be honest and truthful and accurate in your recollection. But am I correct in saying you didn't have a full set of papers made available to you?
I didn't have any papers.
Any papers?
So I did ask for papers, but I was told that I could only have what the inquiry gave me. So the bundle, when I prepared my statement, all I had was the bundle that was sent through to me with the Rule 8 request, which was simply, I think, documents supporting the questions that had been asked. So I didn't have a recollection or an overview from the papers in front of me at the time.
But since this statement was prepared, am I correct in saying that papers have been provided to you?
Some papers have been provided to me, much more extensive than I had for the preparation of the statement.
And am I also correct in saying that's allowed you to refresh your memory on certain areas?
It has.
Thank you. Well, let me first of all say, I also am aware that you've watched some of the evidence to the inquiry.
I have.
Do you have specific witnesses that you've watched, or?
I didn't watch anything of the earlier sections of evidence, and I made a conscious decision not to do that because I didn't know what I would be doing and what you needed me to look at if I was required to prepare a statement. Once I knew I was coming to give evidence, I thought it would be most helpful to the inquiry if I actually knew the types of questions that you were asking, what you were looking for, and so I have managed over the last week to look at some of the witnesses. I've looked at some of Les Brown, I've looked at Lindsay Miller, I looked at James Wolfe. I didn't look at Lord Mulholland because he for the time that was available to me, he was in the investigation before I came in, so I didn't look at him.
Thank you.
I looked at a bit of Stephen McGowan as well.
Right. You will have seen, if you've watched some evidence, that there is a folder in front of you that's for your use. There should be a hard copy of your statement in there.
It is.
You can make reference or make use of that in any way, and it's entirely for your use during giving evidence.
And what I do have in front of me is my own printed out copy of my statement.
Right. And if during the course of giving evidence you think another document might be helpful, if we don't have it available to show on the screen, if you just let me know, we will try and get a copy in the next break.
Okay, I'll do that, thank you.
So if there's anything at all that would assist you, please just let us know.
Okay.
If we go back to the top of your statement, I think you've helpfully set out at the beginning of your statement a detailed summary of your involvement with Crown Office, your appointments during that time, essentially your experience and your background before becoming involved in the investigation into the death of Mr. Bio.
That's great.
And that's at paragraph 1. And you've also set out your experiences of SFIU cases as an advocate depute and your experience of meeting the family of Mr. Bio. And that's at paragraphs 4 and 5. And I don't want to go into those in any detail at this stage. Could we look please at paragraphs 57 to 59? And this relates to training that you have been given as part of your work as an advocate depute. And you say, by 2016, I had been an advocate depute for 8 years. I was experienced in dealing with large and complex cases, including death investigations, both prior to reporting to Crown Counsel and following instruction to proceed. I was experienced in preparing and presenting large and complex cases to juries. I had completed all the annual training courses, together with 8 two-day residential cases. Is that cases?
I think that's meant to say courses.
Courses, thank you. And 59, by 2016, I think I had completed at least 2 separate training modules covering equality and diversity issues. I'm interested in learning a little more about the training courses that you had undergone. Could you explain what the content of those courses was?
So if we're talking about the annual Advocate Depute course, that was at the time I think a 2-night and 2-day course. I think we went on the Friday and worked on the Saturday, Sunday. It's now just we work on the Saturday, Sunday, but we only stay over on the Saturday. But in those, initially, those training courses were 2 nights and 2 days, and a full range of presentations would be made. Sometimes we bring in external speakers, and other times advocate deputes do internal training.
And at one time was that known as Balathi?
It was, and even though it's now in Crieff, it's still known as Balathi.
Is it? Thank you. And you have mentioned here at least 2 separate training modules covering equality and diversity issues. Tell us about that.
So I did a wee bit of refreshing for coming here to give evidence, and I found that the initial course on equality and diversity was rolled out in 2004, and that of course is before I joined the Crown Counsel team. The next training course was 2010, and I was able to access the training schedule for that day, and I was able to see the individual pieces of training that were given. The next one was in 2015. Again, I had the materials for that, but in 2015, when that course was being run, I was on annual leave, but I had access to the actual training materials.
And tell me, did either of those courses that you did attend deal with issues regarding Article 2 investigations?
They did.
Did they deal with Article 14?
I don't recall Article 14 ever being specifically mentioned in the training, but it certainly focused on Article 2 obligations.
Was there any reference in the course which you had the materials for that referred to Article 14?
I don't recall. I didn't go back to the materials to check exactly what was in the actual training.
Was there specific, although they talked about Article 2, was there any specific training given in relation to investigations that dealt with deaths in custody or deaths in custody where race was a factor?
I think there was, but I can't recall the details at this stage.
Right. Do you remember anything at all, even a general recollection?
I have made some notes if you would like me to look at the notes.
Were those notes made in preparation of helping
They were.
answer the questions? Please tell us.
If I can locate them. So the training that I attended was on the 2nd of October 2010. There was a full programme of talks from other advocate deputies, including an approach to diversity and an update with regard to the Chokar and the Jandu inquiry and the aftermath of what happened with the Chokar trial. That is the only details that I've got. I've got noted. There was an advocate deputy diversity booklet given out, but I didn't have a copy. I don't have a copy of that now.
Did you have a copy then?
Yes.
And was that something that you read?
Yes.
Do you remember much about the content?
I don't know.
When you say you were given information about the Chokar and Jandu report, to what extent did that form part of that day's course?
Well, I've noted that the introduction was given by Principal Crown Counsel at the time. That was the welcome. He was the chair. And then at 9:45, and it looks like that was the next talk was approach to diversity. And it looked like that took up a considerable portion of the morning. And that was, as I indicated, the Jandu inquiry, the post-Chokar implementation of the recommendations, and the Equalities Act 2010.
Thank you. We've heard evidence that Mr. Bio died on the 3rd of May 2015. And PERC became involved and carried out an investigation and initially sent a report, or perhaps an interim report, to Crown Office in August of 2015. But then subsequent to that, on the 10th of August 2016, a final PERC report was sent to Crown Office. Now, we've heard evidence that for the 2 years after that final PERC report, so between 2016 and August 2018, that was the period during which the Crown investigation essentially took place, and there was something known as a Crown precognition prepared. Does that all accord with your recollection?
It does, and that was the period during which I was involved.
And the inquiry has documentation available that indicates that Principal Crown Counsel at the time emailed you on the 11th of August 2016 and asked you to become what we've heard was known as the allocated AD, the allocated advocate depute.
And that accords with my memory.
And up until that date, you had had no involvement at all in the investigation into Mr. Bio's death.
Nothing.
Thank you. Could we look at paragraph 31, please? And you talk here in some detail about the Crown Council's role. You say once the reporting agency has made a report to Crown Office, and that reporting agency may sometimes be the police, or it may be PERC, or it may be one of the other organisations. Crown Office initiates an investigation. The results of that investigation are either included in a full Crown recognition or a report to Crown Council for instruction, depending on the type of case. The role of Crown Counsel in the recognition process is varied and dependent on the nature and complexity of the case. In essence, the role of Crown Counsel pre-reporting for CCI, which is Crown Counsel instruction, is to provide direction, where necessary, to ensure that the investigation report, the recognition, has explored all relevant areas and provides all necessary documentation to allow Crown Counsel to make a fully informed decision on criminality. At this stage, Crown Counsel is not involved in analysing or interpreting the information to be included in the recognition. In this case, this was a pre-petition recognition. I was allocated to the case some months after the PERC had reported to Crown Office. The investigation recognition process was already underway. As indicated above, I met with the investigation team and various other officials in September 2016. My input into the process was, as outlined above, high-level advice and direction. Now, I appreciate this was prepared before you had an opportunity to look at the papers. I'd like to talk about the normal common or garden case that might come to Crown Counsel. The Crown recognition in the past would have been delivered to the Advocate Deputes, the Crown Counsel, and they would have picked that up, read through it, and taken a decision on whether to prosecute or not prosecute.
That's great.
And that would be the normal sort of procedure for the majority of cases coming to Crown Counsel.
If it's not an allocated case at petition stage.
And the difference is if there's an allocated Advocate Depute or Crown Counsel, the procedure is changed for that purpose. Now, when is an allocated AD appointed? What type of cases would you say?
Usually the larger, more complex cases are allocated to Advocate Deputes. I'm thinking back to 2016, because it has changed slightly now. We allocate out a greater percentage of cases to Advocate Deputes. But at that time, it was only the larger, more sensitive cases that were allocated out.
And in that situation, where it's a larger, more sensitive investigation, what was the procedure when an allocated AD was brought into a case?
Usually the allocated AD would be given some reading materials in order to inform them about the nature of the case and what was required. And again, it just depended on the stage of preparation of the case, what type of case it was, and what was envisaged in the preparation. As to that would dictate the early interaction with the Advocate Depute.
And in particular, in relation to Mr. Bio, you were sent some reading materials.
I think I was given the 2 PERC reports, and perhaps at that time some of the expert reports as well.
Right. And that was before the Crown recognition had been prepared?
Yes, I didn't receive the Crown recognition until I think into the spring of 2018.
And when you said at the bottom there, high-level advice and direction, I wonder if you could help us understand what that means in practice, or what that meant in practice.
So the Crown Counsel team is an independent team of counsel, of lawyers, of Advocate Deputes. We're not part of Crown Office and Procurator Fiscal Service. So we provide independent legal advice and analysis on cases depending on the stage that they're at and what's being requested. The types of requests that were coming to me in this particular case was, do we need another expert? Who should the expert be? Do you have any advice on what we should be looking at? Here's a timeline. Do we need to be looking at something else? That kind of thing.
So this is prior to the Crown Precaution having been prepared.
Yes.
And requests were coming to you as the allocated AD. What papers were also sent to you when those requests were being made?
I think it depends on what it was that they were asking. Obviously, in order to make those decisions, I had to have a base level knowledge of what stage the investigation was at, and the factual matrix as much as we could determine at that stage. So I've got a note of what I was getting early on. If you would like me to refer to it.
Yes, please do.
So what I've noted here is by the 18th of January, so that's quite far on in the investigation, I had...
Is that January 2017?
2018.
2018, oh.
I had the relevant witness summary from the precognoser. I had a timeline. I had airwave recordings with a synopsis of the recordings, which was in transcript form. I had CCTV timeline, and that included dashcam CCTV, which was synced with the airwaves, and also Ashley Wise's Snapchat clips. So that's what I had by the time it came to January of 2018. Before that, I think what I might have had is a timeline at various points in the earlier 18 months, and expert reports.
What about witness summaries? Would you have had them?
I think I had witness statements. Now, I am aware that there were upwards of 400 statements provided by PERC to Crown Office. I didn't look at all 400, but from my notes and from my understanding of what the things that I'm asking in my emails, I obviously had an in-depth understanding of the statements of the police officers who attended at Harefield Road.
Thank you. Right, we have heard evidence from Les Brown that he prepared a minute, COPFS 03853A, and we've heard from Les Brown that he was the solemn legal manager. He was the head of Cat D at that time, and that the minute he prepared was on the 15th of September 2016. You'll see that on the screen. And so this is the month after the final PERC report has been received by Crown Office. And you'll see that if we move up the screen, we'll see that you are one of the people who's copied into this minute. And it was prepared, as we understand the evidence of Les Brown, in advance of a meeting that was to take place in Crown Office regarding the death of Mr. Bio. And the purpose of the meeting was to identify key issues to be explored at recognition of relevant eyewitnesses to the actions of police officers engaged in the restraint of Mr. Bio. Now, by this stage, I think you had been appointed as the allocated AD, and I wonder what information, whether you remember a meeting taking place with yourself, with Mr. Brown, and with any number of the people who are listed here. We've heard the evidence that Alistair MacLeod had been brought in to essentially pregnose for the Crown Precaution with Erin Campbell at that stage.
I don't recall the details of that meeting, but I do recall being at a meeting. Whether it was a meeting in 2016, I can't remember.
Let's just go through this a minute. You'll see that the background is given, and then the discussion and incremental approach to the investigation and decision-making process has been proposed. Essentially, the first part of the investigative process will be focused upon reaching a decision as to whether there is any basis for taking criminal proceedings against any individual police officer involved in the restraint of Mr. Bio. Does that ring any bells for you?
I've seen the document, so I know what's in the document. Does it remind me of the actual meeting? Not really. My memory is having a lot of contact with Alistair MacLeod. I don't remember meeting Erin at that time. She's now an advocate depute, but I think I only met with Erin once, or even maybe perhaps twice, with regard to this particular case. So I had lots of meetings with Alistair, but I only remember one meeting with Erin. But I understand perhaps I also met with her when we went through the CCTV, and that I think that was done in Crown Office.
All right. Let's leave that for a moment then and go back to your inquiry statement. First of all, at paragraph 4. So if we look at paragraph 4, you'll see halfway down that paragraph, towards the end of the line, it says, "I do not recall race." Do you see that?
Paragraph 4? Yes,
Paragraph 4, fifth
that.
line at
Thank
the
you.
end. "I do not recall race being a particular feature in any of the cases I was involved in, except in the appeal court, where I was involved in cases which included debate on the laws surrounding the inclusion in charges of racial aggravations." Does that remain your recollection today?
It doesn't. So this is the benefit of having time to refresh my memory. I was involved in a case under the Terrorism Act round about that same time. And I think actually, in fact, it came to trial either in 2017 or 2018. And it involved potential viewpoints of white supremacy. And I had a number of consultations with an expert called Professor Feldman, who assisted in informing me of the background to some of the literature that was involved in that case.
And so were there elements of that case that involved consideration of race?
There was elements of far right-wing viewpoints.
Thank you. And can we look at paragraph 54, please? This is a section of your statement called race. 54, "I do not recall race being a factor in any previous death in custody in which I was involved. It may be that race had been a factor in some of the cases in which I issued Crown Counsel's instructions, but I do not recall any particular case." Does that remain correct today?
Apart from what I've just said, because
Apart
I
from what
do
you said.
recall that particular case, and that was a trial that ran, I think, over 3 weeks. So it was quite a detailed trial, and there was a focus on race.
Was that in any way a death in custody?
No.
No. So insofar as 54 relates to a previous death in custody, does that remain the position today?
That's correct. The other case that I'm thinking of was under the Explosives Act and the Terrorism Act.
Thank you. As well as you've explained your experience at that time, did you seek out guidance, information in relation to an investigation after the investigation into the death of Mr. Bio, but an investigation after a black man has come into contact with police?
In what way? What do you mean? Did I seek
I
out?
understand that at one point you went to Crown Prosecution Service down south?
I did, and
Okay.
in the lead up to that, obviously I would have done my own research. That's my practice. Googled, looked on the knowledge bank, see the information that I could find, look to see if I could see any other cases that would assist me, and ultimately I knew that the CPS were more experienced in dealing with this type of case than we were in Scotland, because I wasn't aware that it had happened before, with the particular focus and sensitivities. So I wanted to find out as much as possible as I could about other people's experiences, what they did, and if that could assist us in our investigation and looking at the things that we needed to look at.
You've mentioned the knowledge bank. We've heard some evidence about the knowledge bank. What information did you find that you found helpful?
I can't specifically remember. I did a lot of research at this time. I did a lot of research into sickle cell anemia. I did a lot of research into, not a lot, but a bit of research into Sierra Leone. My geography is not that great, so I did a bit of research into that. Those are the types of things I'd be looking at and doing all the time.
And you mentioned researching or looking for other cases. Did you find any?
Not. Obviously, they were the English cases, and I had a few ultimately from the contact in CPS. I had some of their marking decisions. But for Scottish cases, no, I didn't find anything that assisted me.
And
aside from the ECHR cases, human rights, that kind of thing.
Right. So you looked up ECHR cases,
From
specifically in
recollection.
relation to race?
Yes.
And you've said there were no Scottish cases, but you had some decisions from the CPS available to you, and English decisions. What assistance did you glean from your research into the English decisions?
I think at the time that we went down, Les Brown and I went down to meet the contact in CPS, I think at that time what I was looking for was assurances that everything that they had done with regard to their experience, their built-up knowledge, we had covered, and that's what I was looking for. I was looking for assurances that there wasn't a gap in our investigation, that there wasn't another area that we should have investigated, there wasn't an expert that we didn't have. That's the type of thing that I was looking at.
Did they provide the assurance that there was no gaps in the investigation?
I didn't ask them to provide me with the assurance because there was the person that we met. He had his own case load. I couldn't possibly ask him to sit down and read our whole precognition or all the information, and that wouldn't have been the correct thing to do anyway. What I was looking at was to get as much information as I could about his experience, how he dealt with, how they dealt with these types of investigations. So I wasn't looking for him to make an analysis of the case that was my responsibility. I was just looking to inform myself.
Did you ask him how he dealt with deaths in custody or deaths following police contact where race was a factor?
Absolutely, that was the whole focus of why I went down to speak to him.
What guidance did he give you?
He was very generous with his time. He shared the working of the unit that they had down south. He gave me a number of I think marking statements, I can't remember the right terminology, but the documents that they produced when they marked and decided on criminality in a case. And we talked about a number of high-profile cases that they had at that time. I'm sorry, I can't remember the names of the particular cases.
Don't worry. When you looked at the marking statements used when they decide criminality, was race mentioned on those marking statements?
I think I had 2 or 3 of the marking statements, and of course one of the particular aspects that we were asking about was race and their deaths in custody after restraint where the person was of an ethnic minority. So I don't remember if any of the actual written statements contained those particular circumstances, but it was certainly something that I was interested in discussing.
Were these marking statements templates that they used, or were they completed statements that were perhaps anonymised or not?
I think they were completed statements, and I don't think they were anonymised.
Right.
But
And-
that's only from my recollection.
And of those completed statements, were there sections that dealt specifically with evidence regarding race?
I can't remember because I can't remember if the written ones were in the particular circumstances where race was involved. But it was certainly something that we discussed.
Right. So although the purpose of the meeting was how they dealt with deaths in custody or following police contact where race was a factor, you don't remember if any of the particular examples of marking statements actually dealt with race or ethnic minorities?
Exactly.
Is it possible that the examples you were given with these marking statements did not include race or involved an ethnic minority?
It's absolutely possible.
And was there any discussion between you and the Crown Prosecution Service about where race is a factor, how that would alter or impact on the marking statement?
I don't remember, but I do remember that compared to the types of Crown Council's instructions that we were routinely preparing in Scotland, that those marking statements were much more detailed than here at that stage. Ours are much more detailed now than they were then.
So were the marking statements the equivalent, the English equivalent of a Crown Council's instruction at that time,
I think they
as
were.
opposed to being the equivalent of anything to do with what in Scotland would be a Crown recognition?
Yes.
So it wasn't a narrative, it
No.
wasn't an analysis?
No,
Nothing like
no.
that.
These were the decisions made by the legal teams once they had all the information.
So the examples you gave probably didn't include any death of an ethnic minority?
I can't remember.
Did you at any stage, you've talked about the research, you've talked about the trip to Crown Prosecution Service, did you at any stage discuss with a Miss McQuaid or any other qualified person in Crown Office? We understand she was known as an equality champion. Did you discuss with her whether there were other sources of information or support available to you?
Not at the
to
time.
investigate? Not
Not at the time. I have had subsequent discussions with Ruth McQuaid, but not at the time.
Was that something you considered at the time might have been of assistance?
I didn't consider it at the time, but it may well have been of assistance. I have subsequently been involved in the equality and diversity, and I think last year, the year before, I stood in for the Lord Advocate at the Champions Awards. So I spent, I think, 1 or 2 days at the award ceremony, so I learned a bit about it then.
When you became, or shortly after you became involved as the allocated Advocate Depute, were you aware of any guidelines being available from the IPCC in England in relation to investigations regarding where race is a factor or was a factor?
I think I was, because I think Les Brown and I discussed it, and he directed me towards the IPCC and the report of the Angelini inquiry.
And was that something you considered as part of your role in relation to this particular investigation?
What do you mean?
Did you read the IPCC guidelines?
I can't now remember reading them, but I remember being directed towards them, so I obviously did read them. I also remember reading the report, the Angelini report, but again, I don't remember the details now at this stage.
And was that the Angelini report from 2017 about deaths in custody?
Yes, it was.
And do you remember, even if you don't remember the details of either of those documents, do you remember taking any points forward in terms of your work involving Mr. Bio's death?
I do remember discussing with Les Brown the Angelini report. I don't remember discussing the IPCC guidelines, but certainly the report. Les had read it in much greater detail than I had.
Was there anything that you, thinking back now, was there anything that you read either from the guidelines or from the deaths in custody report that made you question whether everything had been done in relation to Mr. Bio's investigation?
I was constantly questioning that we were trying to, was everything done? Are we looking at the right things? Are we really going that extra mile to unmask any motives? We were constantly questioning and looking to make sure that our investigation was as full as possible. And that was the reason for the trip down to see our English counterpart.
So when you became the allocated AD, unmasking motives was something you considered and wanted to pursue?
Of course, that was the major sensitivity in the case. That was made clear to me from the beginning. It was clear to me from the beginning anyway, because I'd seen the press long before being the instructed advocate deputy.
When you say the beginning, was that from August, September 2016? It was something you were concerned to pursue?
No, I was aware of it from May of 2015, obviously, right, from the press reporting.
Right. And did you take any particular steps yourself or recommend any lines of investigation, particularly with regard to unmasking motives?
I don't recall, but in one of the emails, or perhaps one of the notes that you've got from me attached on one of the reports, is a list of things that required to be done, and there, under the heading mens rea, there is a section on race.
Right. And for the public who may not understand mens rea, could you explain what that meant to you in your notes?
So that's the mental element of a potential crime. So what was in the minds of the potential accused or potential suspects when the circumstances, when the factual matrix is unfolding.
Thank you. And in terms of unmasking motives and investigating motive and what was in the mind of the people who may be accused or what their state of mind, was racial motivation part of that? That was racial motivation something you were also keen to pursue?
Absolutely.
Yeah. Now, let's go back to the minute we looked at a short while ago, COPFS 04543. Oh, sorry, COPFS 03853A. So this is the minute from the 15th of September 2016. You were copied into that, and we noted at the beginning the purpose was to identify key issues to be explored at recognition of relevant eyewitnesses to the actions of the police officers. We've heard evidence from Les Brown about this minute in some detail. You've explained you don't have a detailed recollection of that the meeting that took place. Could we look at page 3, please? And I'm interested in the second paragraph, which is above conclusion. And it says there should also be recognition of the ambulance personnel who attended, including their actions on attendance and the subsequent transportation of Sheku Bayo to hospital. In addition, during this initial investigative stage, all recordings of airwave broadcasts should be listened to and checked for accuracy, with the transcripts provided by PERC, so that the Crown can be satisfied as to the state of knowledge of the officers attending. Similarly, all video footage should be viewed. That reference there to the Crown being satisfied as to the state of knowledge of the officers attending. Is that a factor that is also part of your consideration when you're thinking about what was in the mind of the officers at the time?
Absolutely. I wanted to know what the officers knew when they arrived at the scene, because obviously there was a background of a lot more information with regard to reports in the circumstances of the earlier morning before the contact, and I wanted to know exactly what each officer knew, and we would get that from the airwaves. We also investigated from recollection to see if anyone had used mobile telephones or anyone was in contact in an additional way in addition to the airwaves contact.
So is it fair to take from this minute that when the meeting took place after this minute that this would have been part of the discussion, the state of knowledge of the officers and lines of investigation to pursue that?
Yes.
Would you say that that was something that you were discussing personally that was of interest to you, or was that coming more from the other members of the team?
At the stage of this meeting, I'm listening a lot because I'm just becoming involved. There had been a period of over a year where that information had been coming into Crown Office. So I'm trying to absorb and understand what everyone else knew so that I could bring myself up to speed. So I was participating, bringing my experience from other cases with regard to how to approach the preparation of a case for reporting to Crown Counsel, but I was also listening to the information that they had.
And in relation to the Crown being satisfied as to the state of knowledge of the officers attending, what were your expectations of Alistair MacLeod and Erin Campbell? We've heard other evidence that the precognitions were taken from eyewitnesses between the beginning of October 2016 and completed by towards the end of November 2016. And I'm interested in what your expectations were in relation to the precognition process, taking precognitions.
With regard to the knowledge of the officers?
Yes.
Well, obviously it wasn't the officers that were being precognosed, and I understand that particular sentence to be directed at not so much the precognition of the eyewitnesses, but the analysis of the information that we had about the instructions to the police officers, where they should go, what information they were given, who attended, the sequence of who was attending, the information as it went along, as the incident unfolded, as to the further information that was being provided, whether officers briefed each other when they arrived. So that's the kind of thing that I think they were thinking of in that particular sentence.
Thank you. In terms of precognosing the eyewitnesses, did you have any involvement in directing lines to adopt in relation to particular witnesses, or strategies to adopt with witnesses, or topics to cover?
I don't think on an individual basis I was involved. If you're talking about things like what questions to be asked of a particular witness, I don't think so. Although there might have been a particular piece of evidence that I wanted clarified, that I might say, can we make sure that you raise that with witness X? Aside from that, and I think there was an agreed approach with regard to the witnesses, so that was a more traditional taking of the precognition, asking open questions and allowing a witness to tell their story.
Thank you. And we've heard evidence from Les Brown. Perhaps we could have his statement, SBPI 00419, on the screen, paragraph 105. This is a copy of his inquiry statement, which has been signed by him and he's spoken to in evidence. and it might be easier for us if we just have that on the screen. So you see the first paragraph there, a key element of the incremental strategy approved by the Lord Advocate was to separate out and resolve the issue of potential criminality and to get to a point where Crown Counsel could take a decision in this regard with the necessary confidence, thus permitting the investigation to move forward to other areas in anticipation of an inquiry whose forum had yet to be determined. It had been hoped initially that the necessary further inquiries could be completed relatively quickly. So that reference there is to what's known as an incremental strategy by Les Brown. We've also heard it described as sequential or linear. But my understanding is that initially they were going to look at criminality first and foremost, and then move forward. And then if we can look at the next paragraph, the precognition that was requested by Crown Counsel was created for the limited purpose of enabling Crown Counsel to make a decision on potential criminality, but was not intended to be the end of the investigative process by the Crown, particularly in relation to race and implicit bias, and further detailed inquiry would likely have been undertaken had an FAI been instructed. This would, in my opinion, have been highly likely to have required precognition of the police officers involved, where their approach to the incident would have been probed, scrutinised and evaluated. Does that description of this incremental strategy, also we've heard it's called the sequential strategy, accord with your recollection of the approach that was agreed to be taken to the investigation into Mr. Bio's death?
It does, and that's my understanding of the approach that was taken with regard to all death investigations where there was potential criminality.
And who was it, as far as you recollect, who devised or proposed this strategy?
I don't know. I understand that the SFIU came into being maybe in the 2012, something like that, and I understood that that was the way it worked with regard to the investigation and ultimately the presentation for fatal accident inquiries.
We understand that it was CAPD that dealt with the investigation into Mr. Bio's death. Is that
That's
your
correct.
understanding?
That's correct.
To what extent did you expect race to be considered as part of this precognition process?
It was obviously a very important part of the investigation process because it was an important part from my point of view with regard to the mental element, the mens rea.
So when you talked earlier of the motivation and racial motivation,
Yes.
was it your expectation that that would be considered from the beginning?
Yes.
Did you give directions or instructions or guidance to any of the precognosers at that stage in relation to seeking to identify, seeking to investigate racial motivation?
I don't remember specifically any guidance with regard to race, but I do remember discussing the importance of understanding the mental element, the mens rea, what the officers were thinking when they went into the situation.
Did you make it clear that as part of considering that mental element, that race should be also considered?
Yes, and I've seen that in my handwriting in some of the documents available to the inquiry.
And do you remember specifically which documents? Is this notebooks that you had, or can you help
You
us?
have it. It's part of the information that was given back to me. I could probably find it to let you know
That
what
would
it
be
is.
very
And I think
helpful.
I have
Thank
the
you.
reference as well. Sorry, I can't see. I've got 2 or 3 notes with regard to your numbering of documents. I know that I looked at it just last night, so at a later stage I can probably find it for you.
Over the break or over lunchtime, if you please take your time, and if you could come back to us on that, that'd be very helpful. Now, we have heard from the prognoser Fiona Carnan, who prepared the analysis. So she came in at the end of I was going to say 2016, but actually I think it was later than that.
I think she came in
2017.
at the end of 2017, because
That's
at
right.
some point, as I indicated to you, I didn't have a massive amount of contact with Erin Campbell, and at some point Erin moved on to a new post and was taken away from the investigation. And I think Alistair was doing the bulk of the work. That there was a real push at the beginning of 2018. I had some big cases, trials coming up. I needed to have a full precognition so that I was fully informed and was able then to fit in some consultations before I started a long-running trial, one in the April and then one towards the end of the summer.
Could you explain to the public what you mean by a long-running trial?
Again, in preparation for giving evidence, I looked at some old rotas just to refresh myself of what I was doing at the various times. So, although I was allocated Crown Counsel for this investigation, the bio-investigation, I was, as I said in my statement, providing high-level advice and direction. I had an opportunity, although I don't think a rotated opportunity. I think I just had to fit it in around my other work, to read the materials, to familiarise myself with what was coming in to the Crown Office. And so, as we went along, I'd be able to give Crown Counsel's instructions, but I wasn't only working on this case. At the time, there were, I think, about 30 advocate deputies. We've got more than double that now. And so advocate deputies are not just looking at allocated cases. At that time, I was just appointed Assistant Principal Crown Counsel. So I was doing less management work and more trials. So I would have a full rota of serious and complex trials. And the question you asked me was a long-running trial. I think during the period that I was working on this, I had a 13-week trial, an 8-week trial, a 15-day trial. So those are probably the longer, more complex trials. As well as that, because we were manning all the high courts, I picked up the rotated trials as well. So that would be a 4-day, 5-day trial. I was covering some of them at the same time.
So with other witnesses, we've heard that they were perhaps brought in to focus on the investigation regarding Mr. Bile. That doesn't sound like that was akin to your role as allocated AD.
No, it wasn't. My role was to be, as we went along, to be as informed as I could be, time allowing, on the material that was available to me, and to provide the high-level advice and direction should the team need it. But my involvement was not in the day-to-day preparation of the Crown precognition. And in fact, it would be quite wrong for an advocate deputy to be involved in the day-to-day preparation of the Crown precognition, because the whole point is that we are independent Crown Counsel, that information comes to us as a prepared piece, and then we look at it from an independent viewpoint.
And you mentioned a moment ago that you weren't full-time and you were not on, this was not rotated time that you had available to look at this.
Yes.
And can you explain, you said you were fitting in, explain to us the level of time that you did have to consider papers and work on this investigation? Initially,
I think I had a few days to read the PERC reports. That was quite dense reading and was quite difficult to assimilate a lot of information over that period. My I didn't go through the rotas in detail, but my first block of actual periods where I can see I've got days together out of the rota is not until the early part of 2018. So that's the time where I would be saying to the team, pushing the team, that I needed a final recognition, because I had that time allocated in the rota and I needed to make sure that I had all the information that I required in order to make a final decision, and also to be fully prepared in case I needed to consult with any of the experts.
So until 2018, when you had that time carved out of your diary, can you help the chair understand the sort of level of commitment that you gave to this particular investigation?
It was doing the initial reading, and then the team would send me something, if it was a timeline or it was something to do with the airwaves, or they wanted me to have a look at the CCTV, then I would carve out time in the rota. I would ask for time in the rota for that. As I went through the various rotas, I didn't see the odd day, but I didn't specifically look for that. But that's the type of time commitment that I would be given, 2 or 3 days at a time, until I had a continuous period, and I think that might have been just over a week.
And was that 2018?
That was in the early part of 2018. But that might have then followed with 3 or 4 days here, 3 or 4 days there.
Thank you. We've heard evidence from Fiona Carnan, as I said, and she's given a statement to the inquiry. She said, "It was not part of my remit from Mr. Brown to consider whether there were grounds for an FEI. My role was restricted to an analysis of evidence in respect of any potential criminality by the police. So the remit was limited to analysis of whether there was evidence of criminality." And we've also heard from Mr. Brown on the 19th of April, one of the days he gave evidence, where he was talking about this incremental process. And he was asked questions by the chair about the focus on criminality and what things would be left for further investigation in the event that no proceedings were taken. And Mr. Brown explained that factors such as race and exploration with the officers of their considerations was going to be left until a later stage. And we've also asked Mr. Logue about this. John Logue gave evidence at the previous hearing at 23rd, 24th of April. And he wasn't aware of this incremental strategy being agreed, or the approach that was agreed for this investigation. He took the view, and I'm quote, "What I would expect to happen is that an investigation would identify a number of issues which needed to be considered. Questions of criminality was an immediate or was an obvious issue which would need to be explored in the investigation, and in simple terms was an immediate priority. There may be wider issues which relate to broader learning, which could come out of a fatal accident inquiry or an inquiry of this nature. But the priority would be to reach a decision on the criminal aspects as quickly as possible. But I would not expect that would mean that those individual elements would be isolated off from each other and dealt with one at a time. The investigation I would expect would have an understanding of all of them and be trying to make progress on all of them at the same time. I think our approach as much as possible is to progress the whole investigation." So on the one hand, we've heard from Fiona Carnan, who felt she was only looking at criminality, and her and Les Brown thought race would be dealt with later. I'm summarising, of course. John Logue thought that race would be very much part of the whole picture. And I'm interested in what your expectations were at that time. Was it the incremental strategy where race would be left until a later date, maybe when an FEI was considered? Or was it, as you've said, weaved into the investigation from the beginning?
It's the latter. So it is an incremental approach. but race was very much a focus of the criminal investigation. But it was anticipated that race and other aspects could be dealt with in more detail once the issue of criminality had been decided. So it's not that it was siphoned off and put to one side. It was that we could only go so far, perhaps with regard to race, because the obvious next step, once the step had been taken with regard to criminality, was further statements from police officers. And so that could only be done at the stage where there was a decision on criminality.
So certain elements of the investigation could be left until later, but race as a whole would not be left until later. That was your understanding?
Yes, and of course when we were looking to make a decision with regard to criminality, then we had to make sure that our investigation was focused. So we couldn't go off exploring perhaps something that might be explored in the wider sense at an FAI. We had to stop somewhere, but it definitely was part of that criminal investigation.
But in terms
Sorry to interrupt. Can I just ask you, Ms. Edwards, as this process was going on, did you ever write a document, write a note indicating what you wanted done?
With regard to
Well, first of all, as a general proposition, and secondly, in particular, in relation to the matter of how race was to be addressed.
No, I don't think I ever committed it into a formal writing, apart from the notes, my own notes for myself, and the discussions that were had at meetings.
I mean, do you think it would have assisted if you had done something like that?
It certainly would have assisted me today. And giving evidence to the inquiry. Would it have made a decision with regard to the actual inquiry that was taking place at the time? I'm not sure, because I was satisfied at the time that they were carrying out all the investigations that they could with regard to race, because that was the subject of a number of discussions.
Thank you.
Thank you. We've heard from Mr. Logue, as I explained, and he agreed with the chair's questions that you couldn't consider the question of criminality without considering the question of race. Is that a comment that you would agree with?
I would.
And Mr. Logue would have expected CAPD to investigate race as part of their exercise of investigating criminality. Would you agree with that?
I would.
He also said that he would see an investigation into race as being part of a thorough investigation, and he also said that would be of the kind that would inspire confidence in the family. Would you agree with that?
Yes, there's nothing there that I would disagree with.
Thank you. And we've heard from Stephen McGowan, who said, I was not of the view that what was being held back was consideration of race. Race, insofar as it was relevant to the question of criminality, was something that would be covered. And would you agree with his comments about that?
I would.
Now, we spoke to Les Brown about this in evidence, and he had given an inquiry statement which we've got on the screen. Could we look at page 60, please? Some of his paragraph numbers and answers span a number of pages. It's page 60 that I'm interested in. And it begins, my advice. So I wonder if we can just look down a bit. Or look up. Could we look at the top of the page, please? Here we are. My advice was given against a background where it was accepting that at all times race and racial motivation required to be considered as a continuous process as the inquiry progressed, and that an absence of overt racial motivation should not be regarded as determinative. Consideration of implicit bias and assumptions based on race in the overall approach required to be assessed as the investigation developed and the evidence was gathered. And is that a comment that you would agree with?
I would.
Now, I asked him about an apparent tension that appeared to exist in relation to the evidence from Fiona Carnan, where she said race would be looked at. She was exclusively focused on criminality. We've heard that had she found criminality, she would then have gone on to consider a racial aggravation. But she did not consider race as part of her assessment of criminality. And I asked Mr. Brown about that tension, where he is saying here it's a continuous process, racial motivation should be considered, but that isn't what, apparently, it'll be a matter for the chair, but it wasn't what Fiona Carnan was doing. And I'm interested in your thoughts about the fact that we've heard evidence from Fiona Carnan that isn't the approach she was taking.
To be fair to Fiona Carnan, she was brought into the team quite late in the day, was given a, a specific task with regard to the writing of part of the precognition. I, of course, at the end of the day, had access to the full precognition, which includes all the source documents. So I wasn't too concerned with what finally was in the analysis in the precognition, because it was absolutely open to me to make my own analysis with regard to the information contained in the narrative and in the source documents, and using my knowledge of the case and the information that I'd gleaned in the process of compiling of the team compiling the precognition.
And you've spoken of Crown Counsel being independent and looking at things independently. Was that the approach in which you read through the narrative and the analysis?
Absolutely. I needed those source documents. I needed the precognition, the completed precognition, so I could have a full picture, so I could know what they knew. But that didn't stop me bringing my own analysis. And in fact, that's what my job is, to bring my own analysis, not only from the information highlighted in the narrative, but from the source documents.
We've heard that the narrative was prepared by Alistair MacLeod and Erin Campbell, and the analysis was prepared by Fiona Carnan. And we've heard that the analysis that was undertaken by Fiona Carnan effectively considered criminality alone, and then only was going to consider race insofar as it applied to perhaps racial aggravation to an offence. When you received the Crown precognition, the narrative and the analysis, did you realise that the issue of race had been dealt with in that way by Fiona Carnan?
I obviously would have realised that it wasn't mentioned in the analysis. It is mentioned, there's a section in the narrative, and being involved at a higher level for the previous 2 years, it was a factor that was always there. So whether it was mentioned in the analysis or not really didn't make any difference.
Did you consider it was part of your role to ask Fiona Carnan to go back and to review the analysis part, or to do any further analysis in relation to race and racial motivation?
If I'd had time in the early and late 2018, I might have done that, but I didn't in this particular case. I am aware that I had some of the early draft narratives in, and that as the information was coming in, I'd understood that a further expert had, for example, changed our understanding with regard to the CCTV and the audio that went with the various visual clips. And I understood that at that point that the draft narrative was to be refreshed from that point of view. So I had an involvement at that kind of level if I had thought about it subsequently and I hadn't then moved on to something else, I might have said, I think you should go back and have a look at that. I did something very similar. I was involved in the M9 investigation, which started for me almost immediately when this one finished. And I did that very thing. My analysis of the case and our discussions, I suggested to the team that they go back and look at the analysis and on the basis of the understanding that I had with regard to criminality there. So it's something that I have done before, but it's not something that I did here.
So it would have been open to you in your role as allocated AD?
If I had thought it was important from I guess a record keeping point of view, that would have been open to me.
Did you not consider that an analysis of race and racial motivation was important, even from a record keeping point of view?
It was important, but from my point of view, I was satisfied that I had understood and looked at the source documents and had analysed the information that was available to me, the wider information, in the correct manner. So from a record keeping point of view, then I think that's a fair comment. But again, advocate deputies have to be careful that they are not over-influencing what's in the precognition. That what is coming to us is the work of someone else and not something that we have channeled and produced ourselves. That's not the purpose of the precognition.
When you say you looked at source documents, can you remember now which source documents you analysed in relation to the issue of race and racial motivation?
Well, I won't have looked at all 400 or 500 statements in full. I had the summaries available to me, but I do know from my notes and my subsequent emails and the precognitions that I did and the meetings that I had with the media team at Gartcosh that I had a detailed knowledge of the civilian and police witness statements. Because I was involved, I don't have many memories of meetings, but I do remember going to Gartcosh and speaking to the two technical people there who were going to produce the body positions. And I remember, I think it might actually only have been me that was there that day. So I remember they had produced a provisional CCTV or compilation. I had seen it, and then it wasn't quite my understanding of the witnesses' evidence, so I'd gone back to them and I put detailed propositions to them. So in order to do that, I would have had a pretty good working knowledge of the actual statements.
Which statements in particular did you look at that were most important and relevant to assessing the state of mind, the mindset of the officers?
Okay, well, from recollection, there was nothing in the civilian witnesses that would suggest any overt racism. So there was no shouting at the time of the incident that would suggest overt racism. So I was looking at the individual history of the officers. I think we looked at their disciplinary records. There were a number of officers where there had been previous incidents that we looked at. I looked at some material with regard to another particular live case. I would be looking at the statements of the officers that were given at the time, although I was aware that they weren't given immediately after the incident and there was a time gap in the giving of the statements. So I would be looking at what they said the state of their knowledge was and how that tied in with the information that we knew that went over the airwaves. That was why we were looking really closely as to whether the information that the police officers had was only the airwaves or that they'd had access to other forms of communication, because there were things creeping into, as my recollection is, there were things creeping into the statements that perhaps wouldn't have been in the knowledge of police officers at the time. I also wanted to know a bit more about some of the information that they gave in their statements about the state of alert of the forces in Scotland in general, and any associations that they'd made with other cases. And my recollection was that there was an indication that there was association made with the Lee Rigby case. So those are the kind of things that I would be looking at, and all the other facts and circumstances in order to look at the mens rea.
And did you look at the statements of the police officers with a view specifically to considering racial motivation?
Yes.
And that was even in the absence of any analysis done by Fiona Carnan within the Crown Precaution?
That analysis was coming right at the end of the process.
Right.
We're talking about much earlier in my involvement. The end of the process was really me relaying them to saying to the team, I need you to finish up. I need everything that you're going to give me so that I can move on to the next stage, because this is the time I've got in the rota.
Right. Do you feel now, looking back, that you put the team under some pressure to fit in with your diary and your rota?
It wasn't just pressure to fit in with my diary, it was time pressure. As you've already observed, this linear approach sometimes builds in that extra time frame into an incident and up until FEI, and we were conscious of that. We were conscious of the family, we were conscious of our duties, we were conscious of time passing, and so there was a time pressure.
Right.
We didn't have endless time to spend. We didn't have endless time to spend on the precognition. We really needed to have it finished and for a decision to be made.
Thank you. Now, there was something you mentioned earlier I'd like to touch on. You said an expert had changed your understanding and the draft narrative was refreshed. Do you remember what that was in connection with?
The expert didn't initially change my understanding. That was information that came from the team, and it was something to do with what we are seeing on the video and the airwaves messages. My recollection is it might have been something to do with the call out officer down and the timing, and from recollection, an expert, and I don't recall what expert it was, suggested that the way we'd been looking at it and synchronising it previously was not quite right, and that the officer down was not to do with Nicole Short, and that was actually taking place off camera. That's my recollection, the best of my recollection at this stage.
So it doesn't sound like it was a medical expert. Could it have been an expert in relation to training and restraint and matters of those sorts?
I can't remember if it was the OST expert, because again I know that he came into the case quite late in the day because it took us quite a long time to identify a suitable expert. I can't remember, but I do know that there are some notes and you have them. I also see in the narrative you've got, you have my copy of the papers, so the writing in the narrative and in the papers is mine. And at that stage, there is a bit that says agreed, and that's to do with the dovetailing of the CCTV and the airwaves. You also have my notes, and I was asked about this in my statement, where it says changes something in the narrative, or change something in the narrative, and I think I had pointed out in my statement that it says changes, and that was my understanding that I'd already had a draft narrative at that point.
Right. And when did you receive these draft narratives?
I think as we were going along, as Alistair was completing various sections, he was probably showing them to me and I was reading them.
Right. So were you reading into the narrative as it was being prepared?
Absolutely.
And how many draft narratives did you receive?
I can't remember.
No. Do you remember when you got your first draft narrative?
No, and it might not have been a completed narrative. It might have just been section 1 or section 2, and I will have had sight of those, and that's because I was pushing to say, I need us to produce something.
And do your notes provide anything like an audit trail of what you had at what time? Or?
I'm not as well organised as that. I wish I'd had been,
Right.
and I wish my writing was a little better as well.
Thank you. I'm going to move on now to the next issue I want to cover, but I'm conscious it's now 28 minutes past.
Well, we'll take a 20-minute break at this point. Ms. Graham.
Thank you. I was about to move on to an issue of admissibility of the officer's statements. And we've heard evidence earlier in the inquiry about the Fiona Carn and the Precaution's handling of the statements from the officers that they'd given to PERC on the 4th of June 2015. And she explained to the chair that she had treated them as inadmissible for the purposes of considering criminality against the officers, but she had treated them as admissible for the purposes of looking at their explanations and justifications for the use of force. And she described that as a cautious approach. Now, when we explored that with Les Brown in evidence, he said he was aware that Crown Counsel didn't agree with that, and that there was an alternative approach that was not the cautious approach, but rather, as the officers were at all times treated as witnesses, that their statements would be admissible for all purposes, both insofar as it may relate to evidence of criminality against officers, but also in relation to justification for use of force. And I wondered if that evidence from Les Brown accords with your recollection of your views on admissibility.
I think there are a number of elements there. The first is that I think the cautious approach is to take the Crown case at its highest, potentially, and to say that the statements would be admissible. I think that is the cautious approach. So the maximum that we could have in the available evidence. I formed a view, I don't know if I discussed it with Les before I had the precognition, or as it was coming to me, or once I had the final precognition, which was including the analysis. But I had looked at the case of Gilroy, and I'd formed a view that potentially those statements could be admissible. There may subsequently have been an argument about them, but I could see that there was a good argument to support for if the Crown ultimately there was a criminal trial and the Crown wanted to use those statements. I thought there was a good argument that they would be admissible in terms of the case of Gilroy.
And we've heard evidence that the analysis section of the Crown Precognition did not contain any real discussion or explanation as to the approach taken by the Precognoser. So no reference to case law, no analysis of any arguments, pros, cons, nothing of that sort. Now, I appreciate you've explained earlier before the break that you were the allocated AD. Did you consider, in relation to this issue, to ask Fiona Carnan to go back and present, to redraft the narrative, the analysis, to present an argument and a conclusion on that? Or
No.
to align that with your thoughts?
In terms of my earlier answer, no, I didn't ask her to go and do that.
Do you not think now that there may have been benefit in asking for that to be reviewed, redrafted, for a full analysis to be prepared on the question of admissibility?
I think there would have been benefit in me pointing out that perhaps should be looked at, and to go away and have a look at the case law and come back with a recommendation. I don't think it would have been beneficial for me to say, here's my viewpoint, put it in the analysis. That's not what it's about. Mm-hmm. But it might have been an idea to direct Fiona to say, okay, I think you should go back and have a look at admissibility, without influencing that final recommendation.
And thinking now, do you think that maybe there was an opportunity for Fiona Carnan to do that, and maybe that should have been an opportunity that was taken at the time?
It was an opportunity. I don't think it's something that would have taken very long, but maybe at that stage I was in a better position to make that argument in my own head rather than the case preparer, because obviously I had argued that very point in a number of cases. I had followed the various trials where that had become an issue, so maybe I had more knowledge at that stage. And it may well have been simply a paper exercise
Did
when
you
I know that time was short.
sorry, did you consider that it may have been of benefit to the Precautions, not even just for this case, but for other cases, for you to have shared that knowledge with her?
In retrospect, yes.
Did you put anything down in writing in relation to the question of admissibility yourself? Earlier the chair asked if you'd prepared any notes or any minutes or summaries.
No, there was no specific request for formal CCI and that, of the type that you are anticipating there. If there had been a request, we're struggling with admissibility, can you give us a bit of help on it? Then that's something that I might not have prepared an analysis of the law myself. I might have asked the Crown Counsel trainee to go away and do a paper, and then I would have incorporated that into Crown Counsel's instructions. Reflecting on the break, with regard to the question that the chair asked me about whether in advance I'd prepared something, I guess something similar to a note on the line or the investigative strategy. That wasn't done by me in this case. Obviously, by the time it came to the meeting of the 15th of September, that document or that email or that minute was already prepared. But now, as part of the process in our very large and complex cases, right at the time of reporting, so before there's an SPR from the police, the Standard Prosecution Report, or before one of the other reporting agencies have reported, there may well be an allocated advocate depute right at the beginning, and there is now a detailed investigative strategy drafted, usually by the case preparation team, and it's revised by the advocate depute. So I kind of think of at least 3 large ongoing investigations where there has been a detailed, lengthy investigative strategy which has been revised by the advocate depute and is for the purposes of directing the investigation at the stage of the reporting body.
So that wasn't the position in 2015?
No, and of course by the time I came to be the allocated depute, that we'd long passed that stage.
And if that had been in the position, we've heard, obviously the events happened in May 2015, the interim PERC report was August 2015, and then the final PERC report was August 2016. Nowadays, when would this detailed investigative strategy be prepared?
You might well get an advocate depute allocated right at the stage of May 2015. Before any body has reported in, and that advocate depute will be involved in the same way as I've described in this case, high-level advice and direction, but right from the start.
And if race was anticipated as being a factor in that investigation, would you anticipate that the investigative strategy prepared would incorporate any detailed investigations in relation to race?
And yes, and if you're talking about the type of document that's prepared now, and I have had sight of the 3 specific documents that I'm talking about before they were issued, and yes, they are very, very detailed, particularly with directing, for example, police officers in the types of information that we want with a view to looking at specific crimes.
And that could include mens rea, racial motivation, that type of thing.
That's correct. And over the break I did look at the document that you asked me to look out.
All right.
I think the witness lady emailed in, but the document is COPFS 05190, and mine has an AE on the end of it, so I don't know if yours does as well.
Could you repeat that? COPFS 05190,
190. Yeah.
and there's an A.
AE
Now
at the end.
I've not had that's not reached me yet.
Okay.
What I'll do is when we over the break at lunchtime, I'll look at that document and we'll.
I can tell you what it is. It's the briefing of the 15th of September, and it looks like I had, in advance of that meeting, printed out a copy, and it's my notes at the bottom, and there is a section with regard to mens rea. My recollection is that when I was talking about it earlier was that specifically race was mentioned, but it's not. It's the elements of mens rea that I want investigated.
So there was no mention of race?
There was mention of what was in the minds of the police officer. There was mention of a terrorist act. There was mention of the alert level. You'll be able to see it once you call it.
Well, I understand there was some technical issue. That's why I don't already have it. But I'll look at that hopefully over the lunch break, and we can come back to that.
So that kind of develops the question that you were asking me about Crown Council's input into the investigative strategy. I didn't have an input into that document being prepared. It was obviously presented to me at the meeting, and there are my notes about what further I think should be developed, and potentially what I probably should have done in retrospect, and been having asked that question, perhaps I could have incorporated that into some written document, but I haven't done that, as far as I'm aware.
You've talked about a process now where they have a detailed investigative strategy. Now, I asked you to look at a minute earlier today from the 15th of September 2015, which had been prepared by Les Brown in advance of a meeting he spoke of in evidence. Let me just check the document number. I think it's COPFS 03853A. And this is what we looked at earlier.
That's the document I looked at in the break, but I obviously had a printed out document for the meeting, and I've handwritten on the bottom of it. And that's the reference to the document that I've given you.
Am I correct in thinking that what you've been describing as a detailed investigative strategy that's drafted and revised by an advocate deputy, that's not this type of minute?
It will contain some of the similarities with regard to the next process in the actual investigation, but the document that I'm thinking of is at a much earlier stage and involves the reporting agency as well,
So
if they need direction.
It may be similar to this type of minute. Or
Yes.
Can we look at this minute? We didn't go through the details. We looked at the purpose, the background was given. We've looked briefly at the issue discussion, an incremental approach having been taken. There was a discussion at the bottom of the page we see there. Before approach is made to experts, it's been agreed that the Crown should precautionise all civilian eyewitnesses to observe the arrival of the police at locus and the restraint process together with ambulance personnel who were involved in the transportation of Mr. Bio to hospital. Thereafter, the evidence obtained at precognition will be disclosed to expert witnesses for comment. It is in my view, it is likely the precognitions themselves, or at least the relevant parts, will also require to be disclosed to Amr Anwar. And then there's mention of Mr. Anwar. Then during the precognition of the eyewitnesses, areas of potential conflict with the statements provided by the officers in attendance should be fully explored. One of the main purposes of this exercise is to ascertain the extent to which the account given by civilians coincides with accounts by police. And then, without wishing to be prescriptive, I would suggest the following critical issues require to be explored during the precognition process. And there's mention there of the actions of Mr. Bio prior to the arrival of the police, discharge of sprays, use of batons, actions of him, Mr. Bio, towards police officers, the restraint process, issues about the post-mortem report, issues about one of the witnesses, Ashley Wise. So there's a number of bullet points. We've discussed all of this with Les Brown, who drafted this minute. And then at the bottom, we did look at page 3, and I asked you earlier about ambulance personnel and the state of mind of the officers, that type of thing. So this is a sort of detailed list of bullet points, and they cover a number of different areas on which the Crown have an interest. Is this the type of thing then that is contained in a detailed investigative strategy that's drafted nowadays? Or is it something, nowadays, is it something more longer, more comprehensive?
It is longer and it's more comprehensive. It depends on the nature of the inquiry, but the particular one I'm thinking of was an approach to issues over a wide range. It wasn't a particular incident, so it was a number of potential failings. And the other one I'm thinking about is, again, wide-ranging and doesn't involve one specific case. So it was how often the investigative strategy will target and instruct the police on how to triage. For example, concentrate on X case, perhaps the other case doesn't need to be concentrated on now, that kind of thing.
You've told us before the break today that racial motivation was significant and something you were considering from the very beginning. You've told us just now that you had a copy of this minute before the meeting that you attended, and I'll be corrected if I'm wrong, but this minute doesn't explore the issue of race.
No, it doesn't.
And given your own thoughts about the significance of race and racial motivation and mens rea and the state of mind of the officers, can you explain why there's no mention of that?
Well, obviously I didn't draft the document,
of course,
and
yes.
I came to the meeting. This was essentially the briefing to me. This was the start of my, as I understand it, the start of my involvement. I was satisfied that the information that was being sought would give me enough to start off with looking at mens rea and race, and the notes that I've made at the bottom, which I've referred to and I've given you the number, amplify on how I think the mens rea needs to be developed. Subsequently, I don't know if I was aware at this time, subsequently I was aware that there were the other investigations that were ongoing with regard to race, and that was looking into the disciplinary background of the police officers.
And we've heard evidence that there was a formal letter sent after the interim PERC report, which the letter was dated the 2nd of September, which did raise for the first time the issue of race by the Crown.
Just before this meeting.
Sorry, 2nd of September 2015.
Okay.
So this meeting was 2016, after the final PERC report. Sorry, I should have been clear about that.
Okay.
There was an interim PERC report in 2015, in the August, sent to the Crown, and then a final PERC report sent to the Crown in August 2016. And you became involved after the final PERC report.
That's correct. And my understanding is there was a section in the PERC report dealing with race. That's my recollection. I don't remember the details of it, but I do remember it was in one of the volumes.
And that was the final PERC report. All right, I'll move on from the issue of admissibility. I'd like to ask you about the issue of causation. We heard evidence from Les Brown that we spoke to Fiona Carnan about causation, and she explained that the analysis did not contain any detailed analysis of case law or the test for causation or anything of that sort. And we spoke to Les Brown in evidence about this. And he explained that there was an assumption made and the Crown proceeded on the basis that causation was not going to be an issue. And he gave evidence that you and he had had a conversation about causation. And I think at one point he recollected you giving him a copy of a case called Johnson against HMA, and that your approach on causation was independent of Fiona Carnan, if I can say that. Does that accord with your recollection?
It does.
Can you remember more about the conversation you had with Mr. Brown?
I can't remember when it took place, because obviously I'm only coming to a concluded view once I have managed to consult with the experts, and any outstanding queries that I had after reading the reports was satisfied. I might have formed an initial view when I'm looking at the case of Johnson, and I think the case of Geddes as well I looked at. I suspect those conversations came about the time that we were doing the consultations, which is in the May of 2018, just before I issued my CCI.
So this was after you'd received the analysis from Ms. Carnan?
I think I probably wouldn't have formulated in my head my final position until I knew what my argument would be. Again, what I'm doing is I'm thinking about forward to any potential trial that I would be running. I will be looking at the potential defence objections with regard to causation. So I would be thinking about all the arguments as to what could be brought up as to objections with regard to making that causal link. So all of those things in my head I'm exploring, I'm looking at all the expert medical evidence to support whether I could make a strong argument for a causal link. And I think the Geddes case assisted me in that it doesn't just have to be the medical or expert reports, that the jury is entitled to look at all the circumstances.
So that would be the circumstances in Hayfield Road?
Yes.
At the point at which, well, we've heard evidence that Mr. Bio was rendered unconscious at one point during the restraint. So that evidence would be relevant for the Crown also. Absolutely,
and what that process that internal process that I'm taking you through is a process of analysing the evidence for the Crown at its highest that I would be able to present to a jury. So none of the things about disciplinary records or anything like that. Only the factual basis that I could present to a jury.
What was your view about causation?
I think there was a good argument for a causal link. I think it was perhaps not the initial causal link that I might have thought coming into it with regard to the press reports and the circumstances on the face of it. But I think ultimately the preponderance of experts came down to the conclusion that the struggling against restraint was a significant feature. So rather than asphyxiation being a significant feature, there was another medical mechanism or explanation.
And do you remember now what the post-mortem stated as the cause of death?
I can't remember specifically, but I think it was 1A, 1B, and while being restrained was in there. But I think the reviewing expert and some of the other experts indicated that they thought that the struggling, the extra oxygen requirement for the heart and the other organs was a significant factor.
And restraint was also a significant factor.
Well, the struggling was in the context of the restraint. So I think from memory there was a suggestion that if some others had been doing the post-mortem or issuing the cause of death, that they might have included the word struggling. That's my memory.
Right. But in terms of your approach to considering the Crown's highest case, at its highest, that where Les Brown gave evidence to the chair that causation or the cause of death was a given, would you agree with that?
It was a given in my thinking. That's what that was the basis that I moved forward on.
And then you've mentioned considering potential defence objections. Explain that factor for us, please.
When any advocate deputy is analysing a case that may well result in criminal proceedings, they're looking to the final proceedings, they're looking to admissibility, they're looking for potential answers that an accused person or defendant would come up with. When I say come up with, I don't mean simply make up, I just mean avenues that might be presented. Those are the things that we need to think of in advance to make sure that we've got enough information about that and to make sure that we can counter that argument.
We'll come on to cause of death again later in more detail when I look at the consultations that you had. But from your description, we have a situation where you have disagreed with the analysis in relation to admissibility. You've potentially had a different opinion in relation to causation from the analysis. I'm wondering, were you starting to think that this should have been revised? That you should have gone back to the prognoser and said, I think more analysis is required here, because here are two very clear examples of where you just completely don't agree with the issue of causation or admissibility.
I don't think that's a bad thing. I think that's part of the process, and that's what independent Crown Counsel brings to the decision-making process. I think that's part of our job, and I don't think routinely we will disagree with recommendations and analysis, and that's essentially what we're there for. So I don't see that as a bad thing. I see that as checks and balances.
And in terms of, you've said you had a conversation with Les Brown about causation, at least.
I suspect I had more than one conversation.
I'm sure. But in relation to that, you had a conversation. Was there anything noted or any analysis prepared by you which would have provided some sort of audit trail of the areas where you disagreed or did not, your views did not align with those of the prognoser?
I don't know if that's something that has appeared as we go along, because I think this might have been taking place just prior to me issuing my CCI. And my recollection is that that is in the report to the law officer, to the Lord Advocate at the time.
And for those members of the public who are listening, and we've said CCI means Crown Counsel Instruction, and without going into the analysis of that, can you explain to the public who are listening what a CCI looks like, what it is?
So a Crown Counsel instruction will usually set out the materials that have been considered. They will set out the things that we think needed to be highlighted from the narrative that have been important, any legal analysis to the factual matrix, and then a decision about what should be done. The Crown Counsel's instructions are now all standardised. There is a Crown Counsel instruction template. In the very early days, Crown Counsel's instructions were handwritten, you may remember, on little blue bits of paper, and they were simply attached to the front of the hard copy papers. They may well be brief historically. They might just be 3 words, proceed High Court. By the time I was writing the CCI in this case, they're a bit more detailed, but they're even more detailed now. So now Crown Counsel are directed to the materials that they have considered, the information on the knowledge bank, so the marking instructions, any operating instructions, any other published directives by COPFS. They are directed to apply their mind to the prosecution code, to the materials that have been considered, to, for example, Article 2 considerations and UNCRC, and then ultimately at the bottom of the CCI. At the top of the CCI is the summary, then they go through all that process, and at the bottom any further instructions that follow on from their marking decision. So that wasn't a format in those days, but it was fuller than the handwritten proceed High Court.
And in terms, again, thinking just from the process and procedural side of things, if there were areas where Crown Counsel took an independent view from that expressed in the Crown Precognition. Is that the type of thing that was included within your CCI?
Yes, including an analysis. If I disagreed with something in the analysis or recommendation, then ordinarily I would put that in the CCI.
And that was occurring in 2015?
It was.
2016?
It was.
2018?
Yes. But now there is a particular section in the CCI template which directs an advocate depute to the legal and factual analysis and any case law that they've taken into consideration.
And is that in addition to what is in the Crown Precognition?
It's now meant to be a standalone document. So although if I was doing that now, I couldn't refer to 126 pages of the narrative, but I may summarise the narrative and outline the factual basis that I was taking into account and making my decision on. I did that in the CCI in some detail, but not particularly, not quite to the extent that the way they were directed now.
Can I ask you about some evidence that we heard from James Wolfe in relation to his inquiry statement? And unfortunately, I don't seem to be able to see the document ID. Here it is, SBPI 00529. And this was a statement given to the inquiry by the former Lord Advocate James Wolfe. He was the Lord Advocate at the time that you were allocated as an AD. Can we look at paragraph 90, please? And he said, I have been provided with the narrative and analysis sections of the Crown Precognition. I've been provided with the narrative and analysis sections of the Crown Precognition. The narrative describes, albeit in summary form, the findings of the PERC in relation to both the allegation of racist behaviour on the part of one of the officers and the question of racism within the former Fife Constabulary. I had no involvement in directing or influencing the content of the Crown Precognition. I had no preconception or expectation about the way that the issue of race would be investigated and analysed. This was, in the first instance, for the professional prosecutors charged with preparing the precognition, subject to any direction or instruction from Crown Counsel. I'm interested in, given your evidence about the narrative and the analysis, the areas where your views did not align with that of the analysis contained within the Crown Precognition. We've heard evidence from Mr. Wolfe that he was sent a copy of the narrative and the analysis. And the Chair has some evidence available regarding what parts of that he considered. Did it concern you that there was an analysis prepared which you just simply did not agree with parts of? That information was being sent to the Lord Advocate for his consideration?
At the time, no, because it was accompanied by what I think I called in my statement was a draft CCI. I thought that's what I'd given the Lord Advocate at the time that I reported to him, but now I've had access, it is actually headed a report to the Lord Advocate, and it wasn't a draft CCI. My recollection is that in that report I included my thinking with regard to the various potential issues.
And that included the analysis on, or the lack of analysis on admissibility and the issues regarding causation? I
don't think I pointed out that there was a lack of analysis. I think I probably said, this is my view, or that's my view. And the Lord Advocate, of course, will have been able to see the same things that I saw and may well have come to the same legal conclusion as me.
So in terms of the completed Crown Precognition, which contains the analysis. Was it of any concern to you that there were aspects of that that you clearly didn't agree with?
No, as I said earlier, that I think is part of Crown Counsel's job.
Did you consider going back to the Precognoser to ask for any review in relation to race before matters were then forwarded to the Lord Advocate?
No.
Did you consider asking for a more thorough analysis of Article 14 before matters went to the Lord Advocate?
No. I was happy from the narrative and the source documents that I had as much information as could be gleaned from the opportunities that were available to the Crown at that time.
Could we look at your inquiry statement, please? SBPI 00445. And I'm interested in paragraph 16, first of all. Race was looked at as part of the investigation, with particular emphasis on the previous disciplinary record of the restraint officers. Race did not really feature in the examination of the actual restraint or the medical evidence, except with regard to the prevalence of the genes associated with sickle cell anemia in the Afro-Caribbean population. Now, we've heard that Mr. Bayo was not part of an Afro-Caribbean population. He originally came from Sierra Leone.
I knew that, and I knew that he'd come from Sierra Leone, and I think I indicated to you that I'd done some research about the country and how it came into being. I think where you'll recall I didn't have the papers at the time. My memory was that I had looked at, following a consultation with the expert, I think it was Professor Lucas or Solu, one of the two, with regard to sickle cell anemia. I had looked at an academic paper where the prevalence of the sickle cell gene, the recessive gene in the Afro-Caribbean population had been discussed. And my recollection was I'd done a bit of research on that with regard to the makeup of the population in Sierra Leone. And there was a significant proportion of Afro-Caribbeans in Sierra Leone because of the way the country had come into being. There were resettled slaves from South America, and that, I think, was why I was thinking of the Afro-Caribbean. That, of course, in the name, Mr. Bayo's name, which may be considered to have sort of Creole influences. That's what triggered my memory of Afro-Caribbean. So it was from a genetic point of view.
I see. Thank you. Looking at that, where you say race didn't really feature in the examination of the actual restraint, I'm interested in this. We've heard evidence, and you've told us about your training in relation to Article 2 in conjunction with Article 14. And a number of witnesses have agreed that, and I think you've also agreed, that there has to, as part of that investigation, there have to be reasonable steps taken to unmask racial motivation. And that we've also heard evidence from witnesses that that part of the investigation should be pursued with vigour. And I'm interested in this comment here in your statement that race did not really feature in the examination of the actual restraint. And can you explain why that wasn't considered to be significant, given not just Article 14 and Article 2, but your own evidence about the importance of race and racial motivation?
That my answer to question 16 came on the back of the question that I was asked at paragraph 15.
Well, let's look at paragraph 15. We can look at the actual questions. Here we are, 15. I've read my page 3 of my notebook 2 I'm not sure if it was just Mr. Nelson's account. That's Kevin Nelson, one of the eyewitnesses, that was being discussed at that time. I also wanted to explore what the witness Ashley Wise could see from the window or windows. In addition, I wanted to explore the number of other witnesses' sightlines. When I wrote the abbreviation RECON, I presume I was thinking about a reconstruction to assess and review all available sightlines because of the differing recollections of witnesses and sometimes how those recollections change over time. I wanted, in so far as possible, to establish fixed reference points as a cross-check to either support or challenge the witness's evidence. Now, you said earlier in evidence that really there were no overt examples of race, no shouting or particular language used, and that wasn't specifically significant in relation to racial motivation. But when we look at paragraph 16, and you say race did not really feature in the examination of the actual restraint, I'm interested in what you meant when you said that.
So what I meant about that was, as a background to the question that I was asked previously, which was the reconstruction of the factual matrix. So who did what, when? What could we ultimately say was the Crown theory, something that I could take forward to present to a jury? So it was the individual elements of the actual restraint that we were trying to tease out there. So the actus reus rather than the mens rea. That's what I meant in response to that answer. I have subsequently gone back and looked at the question, and the question is not as specific as that. It does just ask about race, so I have misunderstood the focus of that question.
Well, that's very helpful. So when you said here race didn't really feature in the examination of the actual restraint, you were focusing on the actions.
Yes. So the actus reus as opposed to the mens rea.
So did race feature in the examination of the mens rea, the state of mind?
It did, and you've asked me that already, and I've said absolutely. So the questions that I'm asking in my head, why did that officer do that? Why did he do that at that particular time? But what I needed to be clear in my own mind, first of all, was what was that? What was the as much as possible we could ascertain was the factual matrix. So once we had that, and there might have been points where we just couldn't say this happened or that didn't happen. But that's what we were trying to get to by a thorough investigation of the actual facts. What could we see were the elements of the actual restraint? And then once that was in place, I could ask that question. Why did that happen? Why did that officer do that? Why did that take place then? Why was something else not done? Was that reasonable?
And in terms of this, you said it was going on, that was the thought process going on in your own head.
Yes.
Was there any analysis that we could look at on paper where we could follow that rationale, that process? You've said you were asking yourself, why did the police officer do that? Was that reasonable?
So the thing that ultimately came to help me with that, so when I'm looking at a case, I'm reconstructing in my head, I'm asking questions, and if there is a gap where I don't know the answer, it's either because I'm not understanding what's been told to me or I simply don't have that information, that's when I look around and say, okay, I need further information on that, or I need an expert to help me with that. I might be satisfied that as far as we can go, I've understood the factual matrix, but I don't understand necessarily what's coming into play, and then I need an expert to help me.
And can you explain to the public listening how, on the one hand, you're looking at the state of mind and what's in the head of the officer, why he may have done something, and how an expert can help you make that assessment?
So the expert, and the particular one I'm thinking about, is the OST expert. The expert will help me understand what is normal or reasonable when a particular officer is faced with situation X or situation Y.
Now, we may come back to this after lunch, but you're talking about situation X or situation Y, and if you've listened to any of the previous evidence from Mr. Wolfe, you may recollect that I asked him about a technique that's used by lawyers when perhaps there's a dispute as to what the correct or the true factual position is, and that sometimes lawyers will adopt hypotheses. When you talk about situation X or situation Y, is that what you're talking about?
Yes. If there's a dispute about the precise factual matrix, then we would want to explore that with an expert.
And when you say you would explore it with an expert, again, can you explain to people what you mean by that?
Well, it might be in the source documents that the expert's been given, and so the information that's available to me is already available to the expert. Or it might be something that was specifically asked in the letter of instruction.
So if there are, say, two alternative possible factual positions, you can explore situation X with the expert as one hypothesis, or you can explore the other as assume these are the facts, the true facts, and we will look at that with the expert. Is that the approach that you would take?
Yes.
With experts at consultation?
Yes. By the time of consultation, I would hope to have in my own head a Crown theory, at least a core theory, and so I would hope to be able to put that position to an expert, if that's not already been addressed in the report.
Would you exclusively look at that core theory, or would you say there are two versions of events here and I want to explore both of them with you as an expert?
From memory, I'm not even sure here that there was two versions of a particular theory. I think there was lots of interconnecting but not necessarily consistent pieces of information. I would want at least, perhaps not at the stage of deciding criminality, but by the time I went to a trial, I would be wanting to make sure that I had explored all avenues with an expert, because that's how I would prepare for a trial, because I would know that counsel for the accused would be putting particular scenarios to an expert, so I would want to deal with that. At the stage of a pre-petition, it's not often that Crown Counsel would consult with experts, only in the bigger cases, although now it's routinely done before we mark Section 1 road traffics. At that time, what I was looking at again was the Crown evidence at its highest. So something potentially that would be most prejudicial, I would be wanting to make sure that the expert has that information. So if you like, the looking at the Crown evidence which supports criminality to the greatest extent. That would be what, at that stage, I would be hoping to get from an expert. It might be later down the line in preparation for trial that I would start looking at different hypotheses.
So you look at the most prejudicial version of the facts, and prejudicial being prejudicial against the potential accused.
Exactly.
So that is the Crown's case at its highest.
Yes.
That's the best evidence the Crown would potentially be able to present at a trial.
Yes.
To prove a criminal charge against the accused.
Yes.
And at the point of assessing criminality, I think you said, that is what you look at, the best Crown case.
Yes, because this is a pre-petition recognition. Nobody's appeared on petition. There hasn't been a decision at this stage with regard to criminality.
So the one where the facts look the worst for the accused.
Yes.
Can I ask you to look at paragraph 35, please? your statements on the screen. I do not think that race was a particular focus in the Crown precognition, aside from those areas mentioned above. It was, however, a fact that Mr. Bile was of Afro-Caribbean descent and was therefore one of the matters I took into account when assessing the reasonableness of the officer's decision-making process. And again, I wonder if you'd wish to further expand on this paragraph, because what you say here is that race wasn't a particular focus in the Crown precognition. Obviously, you've been explaining the distinctions between actions and mental state, but do you feel this fairly reflects your position now?
It probably doesn't. It probably does not give sufficient emphasis as to what we were looking at with regard to the mental element. I do remember that there was a lot of work put into the actus reus, that something that we could say was the evidence at its highest. There was a huge amount of work trying to tease out all the individual elements, trying to get as much as possible from the technology and from the material that we had. So enhancing CCTV, linking up the CCTV with the dash cam, with the Snapchat, with the airwaves. I recollect also that the CCTV from the pub, I think, on the corner, there was a huge amount of work put into that to see if we could maximise the information, that we could develop that, to see if we could do anything about enhancing it. It was ultimately enhanced. It didn't really help much, but there really was a huge amount of work went into that. So that's what I meant when there was the focus. A lot of work went into trying to establish the factual matrix. That doesn't mean that there wasn't work going into the mental element, but the mental element is going to come from the facts and circumstances, because the only other place that it could come from, apart from the history, was from the officers themselves, and that wasn't an option available at that stage. So the further exploration by us about what they were thinking, what they knew, we were constrained by what had been given to us, and we couldn't go back after that, because by that time it was a criminal investigation. Suspicion had crystallised, and so it would not have been proper to go back and take a further statement.
So a huge amount of work is being done in relation to the timeline, what happened, when it happened, and the actions that were taken by the officers in relation to Mr. Bile. And that is going to be sort of crucial for any analysis, not just in relation to the events themselves and how they unfolded, but also in relation to possible conclusions to be drawn or inferences to be drawn in relation to their mens rea, their mental state, their state of mind. So you've talked about having a timeline at different stages. We've also had the benefit of hearing evidence about the timeline and the points at which events unfolded and when they unfolded. And we've heard evidence that between the officers parking the first van at the scene and Mr. Bile being shoulder charged or wrestled, bear hugged to the ground on Hayfield Road was a particular length of period of time. Now, depending on how you analyse it, it could be 59 seconds or it could be just over 70 seconds. And that will be a matter for the chair to draw conclusions on that.
My recollection, as I sit here now, was about 2 minutes.
Right. Well, our evidence is slightly different to that, but a short period of time between the first van being parked and Mr. Bile being restrained on the ground. Shoulder charged to the ground and reaching the ground, if I can call it that. And during that short period of time, officers had attempted to discharge sprays, PAVA and CS spray, up to 6 times, that he had been battened to the head 2 or 3 times, that he had been battened to the arms or the body 2 or 3 times. And all of that occurred in what appears to be a short period. Now, if you were doing a huge amount of work in relation to the timeline, was it part of your consideration, was it part of the investigation, that the speed at which the officers elected to adopt force and to use force against Mr. Bio may have given rise to inferences or conclusions in relation to bias?
That's exactly what I was talking about earlier, and you taking to me with regard to establishing the facts and circumstances, because that's the only way that we could tease that out without having to actually speak directly to the officers. So my recollection is that when the final timeline is produced, it has a counter on the right-hand side, and there's a counter running all the time. And so for each individual stage, we think we know as much as we can what's happening in each individual part, and where the evidence of Ashley Wise's Snapchats fit in, where the evidence of, I think, one of the neighbours, is it Mr. Nelson, where his evidence fits in. So that was the process in the timeline. That was something that it was very important that the OST expert assisted us with regard to what's normal, what's reasonable, what would you expect when a police officer arrives with the information that he has. So that was why it was important that we knew exactly what the first officers knew. So those are the kind of things that we're looking for the expert to assist us with. We can look at the factual matrix, we can establish that as much as we can, but we need that little bit further help to understand whether that's reasonable or not, apart from applying common sense.
Looking at that issue about the speed at which events unfolded, would you agree there was nothing in the analysis that really focused on the speed at which events unfolded and potential inferences regarding race or bias or racial motivation that could have been drawn?
I don't remember whether it's in the narrative or not, because I think there's quite a detailed part of the narrative about what happened in the timeline. I don't think that the narrative, as I recall, is 126 pages long. The analysis is very much shorter, and I'm not sure that it was necessary to take it stage by stage through that. Ought there to have been a final conclusion, potentially, with regard to the OST expert? Perhaps. But I don't remember whether the final consultation with the expert, in fact, that took place because Lord Advocate asked me to go back and consult with the expert. So that final stage didn't come into place. So the final consultation with the expert was long after the analysis was prepared.
Right, I think we'll have to break this down slightly, if I may. You have been prepared with a narrative and an analysis when you, in early 2018, and then you embark on a series of consultations.
I do.
And at some point in August 2018, you do your Crown Counsel's instructions and you discuss that with the Lord Advocate. And I think James Wolfe gave evidence that he asked you to go back and speak to an expert. And
I think it was the OST expert.
That was the OST
Yes.
expert. And that was at some, do you remember when that was?
In between the report to Lord Advocate and issuing the final CCI. I was in a trial in July, so I suspect it was towards the beginning of August.
And what was the specific issue that you were addressing with, we know him to be Martin Graves, the OST expert. What was the specific issue you were addressing with him at that consultation?
I'm sorry, I can't remember.
We'll maybe come back to this. Do you now...
It might, sorry to interrupt you, it might be that I hadn't consulted with him at all.
We'll come back
remember.
to this. Is it your recollection now that in the narrative, as part of the Crown Precaution, that this issue about the speed at which events unfolded and the issue of race or racial motivation, the issue of potential bias, was analysed, considered, discussed, either within the narrative or in any other part of the Crown Precaution?
I don't think specifically with regard to the timeline of the restraint.
So that was never considered?
I'm sure it was considered by me.
Right.
I'm sure it was considered by the investigating team, because we pored over the timeline and we looked in detail at the officers, what their mens rea was, whether that was reasonable, whether it was justifiable, and then ultimately the final piece of that picture is the expert.
And when was that done?
The consultation with the expert.
When did you consider the issue of mens rea and the issue of speed?
All the way through, when we're looking at the timeline about what's happening and what the officers are doing. I think what you're asking me was, did I specifically say, let's discuss Article 2, Article 14 with regard to what happened at 3 minutes and 10 seconds, or what happened at 4 minutes and 2 seconds. No, I don't remember that kind of consultation, but it was there all the time. The consideration was there all the time.
Do you remember asking yourself, you've talked about whether actions taken were reasonable, why police officers did that. Did you ask yourself why officers elected to use force within such a short period, a short time scale?
Yes, because that comes into the question, was that a reasonable reaction? If you are faced with scenario X, is it reasonable to do Y? Or is there another option? Would that other option have worked? And that's again something that we explored with some of the other experts.
Did you consider racial motivation or bias?
As a baseline, yes, because it was there all the time. What's in the officer's head? Why did they do that? Is it because Mr. Bio is black? That was a question that was overarching question over the whole investigation.
And is that a topic that you discussed with Martin Graves, the OST expert?
I can't remember, because I can't remember the actual consultation.
Was there any other expert that you discussed that issue with?
The other experts that I'm talking about was this idea that that it's potential to talk someone down in those circumstances, and so that's when we were exploring the potential acute psychosis as a result of potential drug ingestion. Did we specifically, with those medical experts, explore race? No, I don't think so. I think their answers to the questions I was asking on the factual matrix would have influenced the way I was analysing the information.
Did you provide a factual matrix to Martin Graves when you recall consulting with him, from which you then asked for views about whether the police could have acted out of racial bias?
I don't think so.
And why would you not have done that, given the issue of mens rea and racial bias was of such significance?
As you're asking me the question now, I think the answer I would give is that might not be something for that particular expert, that's something at the end of the day for a fact finder. So if that expert says to me that is not a reasonable response, then the follow-up question is, why not? in most of the answers that we got from the OST expert was that is a reasonable response. Given the range of options and the factual matrix and the circumstances that the officers were faced with, then that response was reasonable. If the answer had been that was not reasonable, then that it would be a matter for the fact finder ultimately why that wasn't reasonable. What was the motivation? What was the mens rea? What was the thinking in the officer's mind?
Did you put to Martin Graves a factual hypothesis where you explored the limits of a reasonable response from an unbiased, hypothetically reasonable police officer?
Yes, I think we did, because my recollection was that the information that he gave us at consultation was we put a number of elements from the evidence. Now, my recollection is he had the evidence because he had the statements and he had the CCTV and the timeline. But my recollection is that we specifically asked about observations of civilian witnesses who might be describing a pile-up, lots of people on top of Mr. Bayo, people, essentially everyone piling up. And I remember that his answer was, often in those types of situations, the gold standard for restraint, which is someone at the head, someone at each arm, one person at each leg, 5 people, that my recollection is that was what he said was a gold standard, often looks like overkill from an impartial observer's point of view.
I can understand the issue of restraint and excessive force. The point I'm asking you about is the speed at which the officers elected to use force, and whether you painted a factual hypothesis to Mr. Graves for his consideration about whether their election to use force within that short time scale was within the range of reasonable responses by a reasonable officer.
Absolutely, that was explored.
You absolutely explored that
Absolutely.
with him.
So the timing, so an officer arrives at the scene, sees X, does X. What's your response to that? Is that reasonable or not? An officer does X at X time. Is that reasonable? I think you've asked me earlier on, did I then ask him about race in that discussion? No, I don't think I then went on to ask.
I'll have to come back to this. I apologise, I've gone over.
It's all right. Well, we'll stop for lunch and sit at 2 o'clock.